Good afternoon. Welcome to Fair Maps for the People, How Redistricting Shaped the 2022 Election. I'm Manal Haddad, Senior Communications Manager for Voting Rights and Redistricting at Campaign Legal Center. Thank you so much for joining us today. CLC is a national nonpartisan organization that works to advance democracy through law at the federal, state, and local levels. We fight for every American's right to participate in the democratic process, and we believe our democracy should be transparent, accountable, and inclusive. Every 10 years, states engage in the process of redistricting, the redrawing of district boundaries to reflect changes in the population. When done correctly, this process ensures every voice is heard and every vote is counted equally in our elections. However, when the drawing of voting maps is left in the hands of politicians, they often rig the system to benefit themselves and manipulate voting maps to dictate the outcome of elections. They often do this in two ways, through partisan gerrymandering and racial vote dilution. The result is dysfunction, distrust, and a government that ignores the will of the people it was formed to serve. Today, we will examine federal and state court decisions in redistricting cases that shaped the 2022 election cycle, compare states with fair maps to states where maps were gerrymandered or discriminated against voters of color, and discuss solutions that are most likely to produce fair maps. Now, I would like to turn it over to our moderator for today, Mark Joseph Stern, to introduce the other panelists. Mark is a senior writer at Slate magazine who covers courts and the law. He's based in Washington, D.C., and has covered the U.S. Supreme Court, federal appellate and district courts, and state and local courts since 2013. Mark also holds a JD from Georgetown University Law Center. I'll let you take it from here, Mark.
Thank you so much, Manal. I really appreciate that introduction. Before we get to our discussion, I just want to go over a few quick housekeeping items. So during the conversation, please use the comment section on YouTube or Facebook to submit your questions for members of the panel. At the end, we will start the question and answer section. We'll do our best to get to each question, but of course, we might not be able to answer each and every one. If you are not able to get a question answered by our experts today, and you're a member of the press who really wants to know what our experts here think, just send an email to media@campaignlegal.org. And if you're a member of the public and are similarly saddened that we didn't get a chance to answer your question, just shoot off an email to info@campaignlegal.org. Now, I would like to introduce today's panel. Mark Gaber is the Senior Director of Redistricting at CLC and manages CLC's work to achieve fair maps for racial and language minority groups and to curb the influence of partisanship in redistricting. Prior to joining CLC, Mark was an associate at Jenner & Block LLP and is a graduate of Stanford Law School. Welcome. Next, I would like to introduce Ruth Greenwood. Ruth is the director of the Election Law Clinic at Harvard Law School, where she engages in election law litigation and advocacy while training the next generation of election lawyers who we will desperately need to keep fighting the good fight. Ruth was previously co-director of voting rights and redistricting at the Campaign Legal Center, where she litigated cases to end partisan gerrymandering and promote minority representation. Ruth is a graduate of Columbia Law School. Welcome, Ruth. Finally, we have our last Mark. There are three of us here, a new record for me. And I'm so excited to be chatting with my fellow Marks and a Ruth today. This is Mark Niesse. Welcome, Mark Niesse. Mark has been a reporter for the Atlanta Journal-Constitution since 2013, where he covers voting rights, elections, and the Georgia government. Niesse previously worked for the Associated Press in Atlanta, Montgomery, and Honolulu. We should talk afterwards about how you get that Honolulu assignment, FYI. And he reported for the Daily Report and the Santiago Times in Chile. Also some questions there for after the show. Mark grew up in the Atlanta area and graduated from the University of Georgia. Thank you all to the two Marks and Ruth for joining us today. Thank you to our audience for listening in on what's sure to be an excellent conversation. And I want to jump right in. So I'm going to start with the one non-Mark here. Ruth, I would like to just begin with the basics for anyone who is not already super familiar with what we're discussing today. Can you sort of just talk briefly about what constitutes partisan gerrymandering and racial vote dilution and why it's something we should care about in 2023?
Sure. And thank you for having me here. I'm always happy to talk about this. I'll start with the why you should care about it. Basically, redistricting is about power and how power is distributed in the country, at the state level, at the local level, and so on. And so if you have gerrymandering of one type or another, you're essentially getting more representatives for one group than they should get. We can talk about what one should get, and less representatives from another group. So in the context of something like racial vote dilution, you end up with candidates of choice from the white community in greater numbers or greater proportions than from communities of color. And that can be differently defined, right? It might be in one place that a Black community is cohesive and under the Voting Rights Act should be able to elect a candidate of choice. In other places, that could be Black plus Latino plus Asian communities and so on. So that's sort of racial vote dilution. In terms of gerrymandering, partisan gerrymandering is essentially where you end up with skews, right? I mean, the easiest example to understand from the last decade, we had all these places, I was in the Midwest, right, where you would get in Michigan and Wisconsin, more people would vote for Democrats for like state legislature, yet more Republicans would be in the state legislature. So that sort of counter-majoritarian outcome is a very visceral way to understand partisan gerrymandering. But there can also be a skew, right? It could be that the percentages aren't sort of lining up in what we would describe as a fair way. And how you look at that, is something we learn from the case law and from political science. And then the last one, sort of racial gerrymandering, is a little different to racial vote dilution in legally. It's looking at where you essentially target people based on their race and stick them all in a district, right? So the classic examples have been cases where people drawing the lines have identified people purely by their race and said, you are all Black, we think you're all the same as each other, we're putting you all into a district, and you end up with a district that's 60, 70, 80% Black. And that not only gets at questions of classification, but also can affect power, right? If you're putting so many people in one area, then you're not able to get power in other places. So that's what they are, roughly.
Thank you. And I think correct me if I'm wrong, I tend to use racial vote dilution and racial gerrymandering interchangeably. Do you feel strongly that we should never say racial gerrymandering, that we should keep a firm distinction between those things?
I'm not a journalist, right? So in the legal world, they are separate causes of action. I think that racial gerrymandering can sometimes cause vote dilution, but
right.
There's other times where it's just a harm in itself. It might be that you've drawn a 60% district, and it's not as though you could draw, two majority or two minority opportunity districts, but you could have a group of Black voters in a separate district that would together have some level of influence or power. And so it's not so much that we would call it, a dilution, which I think of as a Voting Rights Act Section 2 claim. Racial gerrymandering is this sort of different cause of action.
Right.
That's why I use them differently, but we can use them all.
No, that's an important distinction to preserve in this conversation. Thank you. I appreciate that clarification. Clearly, a lot of room for mischief here. Does anybody have anything to add to Ruth's kind of précis before we move on? Yeah, I think she covered the waterfront. So, Mark G, I'm going to turn to you. And I want to talk about an issue that I'm somewhat obsessed with, which is the influence that 2020 redistricting had on the 2022 midterm elections, specifically the race for House of Representatives. I have written, and I remain convinced, that control of the House was determined by a few key court decisions in redistricting cases. I know we'll talk about a bunch of them today, but let's start with two that the Supreme Court weighed in on in a decisive manner, Merrill v. Milligan and Ardoin v. Robinson. Can you talk about how those decisions shaped the congressional races in Alabama and Louisiana and how they may have had an impact on overall control of the House?
Yeah, absolutely. So, and thanks for having me. I think the Republicans have a 5-seat majority. I think it's 222 seats in the House. And, you mentioned 2 cases, that's 2 of 5. So that's getting us close already to the deciding factor. So, as a result of these 2 decisions, and for those folks who don't know, the Merrill v. Milligan is the Alabama case that's currently pending in the Supreme Court that gets to, the meaning and the existence of Section 2 of the Voting Rights Act as a limit on states' redistricting power. And the lower court there, which was a panel that included 2 judges appointed by President Trump, concluded that it was a sort of open and shut case under the existing precedent for Section 2 of the Voting Rights Act, that Alabama should have drawn a second district in which Black voters would have the opportunity to elect their preferred candidates to Congress. For a long time, only one of, I believe, 7 congressional seats in Alabama has been a district where Black voters have elected their preferred candidate. And because of racially polarized voting, which has gotten just even more extreme in Alabama over time, that means that there's just one district that a Democrat is elected from in Alabama. And this would have had the map that the plaintiff sought, or that the court would have gone into place, that would have been an additional Democratic seat in Alabama. And the same is the case in Louisiana, where the court determined that the law required a second district in Louisiana. There's only one right now. And again, there's only one Democrat in the Louisiana delegation. That'd be another Democratic seat there. So, and we'll talk a little bit about sort of the ripple effect from the Supreme Court's involvement in other states. But clearly that, with 2 of the 5 seats being decided right there, that gets you pretty far toward deciding the majority in Congress. And I think that, as Chief Justice Roberts recognized in his dissent from the stay in the Alabama case, the panel followed the existing law exactly. And there was sort of really no question under existing law that a second district was required. And so either the court is going to do something to Section 2, or the view will just be that 9 months before the election is too soon to make a change. And so we'll find out in June what that is. But that decision will have ramifications on the 2024 elections, certainly.
Yeah. So I think obviously these cases are a really great illustration of the kind of vote dilution that that Ruth was talking about. Could you focus a little more on the Alabama maps and like how lawmakers packed voters into that particular district? Because I have looked at the map that now is in place, thanks to the Supreme Court, that was in place in 2022. And it's really remarkable to see that it sort of snakes from Montgomery to Birmingham. I'm not like an expert on Alabama geography or communities, but it doesn't seem like the most organic shape for a district.
No, it's not. And, we filed an amicus brief in the case and showed how, you would draw alternative maps that considered race not at all, where you'd have 2 districts that would perform to elect Black voters candidates of choice. And so, as you said, the district sort of cuts through, I think it's Jefferson County, where Birmingham is located, and then goes sort of southwest from there. And violates the state constitution's whole county provision and, all sorts of other traditional districting criteria, and makes those cuts in Birmingham sort of starkly along racial lines, and which is ironic because the state is saying that applying the Voting Rights Act would require it to make, race-based districting decisions. It appears quite clearly that, whether it was made this decade or whether they just carried it through from the last time, those decisions have already been made, and so you're right that the map itself sort of betrays the argument that the state is making in front of the Supreme Court, and there certainly are any number of alternatives available, and it wasn't just it's interesting, and so there's different iterations for how states can do this. They can pack into one district, they can crack across several, or a combination of that. I think Alabama's is somewhat of a combination of that. The number of Black voters is not like astronomical in that district, but it's dilutive because it does to a degree pack them, but it also there's a large number of voters in the Black Belt and in Mobile who are left outside of a performing district, and so that that's another route to dilute voters.
Right, right. Thank you. And Mark mentioned this, but for anyone who's not paying super close attention to the niceties of the procedure in these cases, as Mark said, this came to the Supreme Court on the shadow docket early last year after that 3-judge court had said, look, this is a clear violation of the Voting Rights Act. And by a 5-4 vote, the Supreme Court kept this racist map in place. And the reasons why are somewhat unclear. But even Chief Justice Roberts, who is an avowed foe of the Voting Rights Act, as we know from decisions like Shelby County, thought that the lower court had applied the law correctly, as Mark said. And now the court is considering that case on the merits and is going to issue a decision probably in May or June that lets us know, I think it's fair to say, like, whether Section 2 of the Voting Rights Act still exists. Like, the stakes in this case seem to be extremely high.
I don't know that I go as far as to say whether it exists. Like, I know that there has been a request to sort of rule it unconstitutional. I think more likely this is going to be a sort of death by 1,000 cuts thing. So the slightly less extreme position is asking for Section 2 to apply in a way that is helpful to not that many people, but somewhat helpful, the race by baseline. And then there's also a version that's, I think, sort of Kavanaugh and Barrett seemed to float a little bit of oral argument, which is like, well, let's just like muddy up the test a little, so it's still there, technically possible for you to bring these claims, but like in reality, poor, bad judges can rule against you. So I feel like you would get more outrage if it was just like a straight up, we're getting rid of it. Instead, it's going to be just this slow, terrible demise that's harder to rail against. But there we go.
Yeah, no, I appreciate that forecast. So let's turn from Alabama now to Georgia. And Mark N., this one is for you. I know in Georgia, a federal judge found that the state's new maps violated Section 2 of the Voting Rights Act, but allowed those maps to remain in place for the 2022 election. Can you talk a little bit about the court's decision and, the court's reasoning for letting this map stay in place despite it being unlawful, and what impact that ultimately had on the vote in Georgia in November?
Sure. So this court case on motions for preliminary injunction was going on at the same time that the Supreme Court was weighing the Alabama case. And so the 5-4 decision that Mark Gaber was just talking about came down in the middle of this case being litigated in federal court in Atlanta, and that factored into the Georgia decision. So ultimately what happened is District Judge Steve Jones weighed the factors that you have to consider when looking at whether a redistricting map violates the Voting Rights Act. And on almost all of the factors, he did find that the evidence weighed in favor of the plaintiffs and that they had a substantial likelihood of success. So he looked at whether minority groups were sufficiently large and geographically compact, whether they were politically cohesive, whether there was history of discrimination, racially polarized voting, denial of minority access, all these jingles factors and Senate factors that we always hear about in redistricting cases that rely on the Voting Rights Act. But then what he did, while finding that on almost all of those factors weighing in favor of the plaintiffs, he also weighed the balance of the interest, right? How he weighed whether the public interest of the state of Georgia would be significantly undermined by altering the election calendar and unwinding the electoral process at this point. So what we heard in court was a lot of testimony about how the election was already underway even in spring of last year, with candidate qualifying and primary preparation and ballot formatting, polling place locations being set, and also looking at the way things were going at the Supreme Court in the Merrill case and understanding that the Supreme Court had put on hold the district court ruling, or I suppose it was the appellate court ruling in Alabama. He weighed those interests and decided not to invalidate Georgia's redrawn maps. And the impact of that was what was designed by the Georgia General Assembly. We did end up with a pretty clear gain of 1 seat for the Republican Party among Georgia's 14 congressional districts. It was 8-6. The congressional map in Georgia was redrawn so that the district in Northwest Atlanta that was held by U.S. Representative Lucy McBath that became a majority Republican district. And then Lucy McBath ran for the 7th Congressional District against Representative Carolyn Bourdeaux in the primary and defeated her. So the result was that Republicans gained a seat in Congress because that's how the map was designed. It was made by the Republican majority in the General Assembly to give them an advantage in Congress. And we also saw similar changes at the state level in the state Senate and the state House, where the Republican Party was able to safeguard their majority in both the House and Senate and really insulate themselves in future years as well, reducing the number of competitive districts and delaying the time before districts change their composition, because you have more strongly Republican districts and more strongly Democratic districts, and fewer competitive districts in the middle that could switch hands. So it's going to take a longer time of demographic and population change for these districts to become competitive. But we always see that each decade. Near the end of the decade, the maps don't always look the way they did when redistricting was done. So what we saw is that the process that the General Assembly approved was successful, and that case is still alive. It will go to full trial probably this year, and then we'll see a longer term decision after the judge already found in favor of the plaintiffs on many of the factors that are considered.
Thank you. Very helpful. So, you mentioned that we're in a situation now in Georgia where there's a lot of extreme Republican districts and a lot of extreme Democratic districts and not a lot of competitive seats. I'm curious how you, as an observer and reporter on Georgia politics, feel that trend may affect lawmaking in Georgia and the state house. I've heard a lot of theories about how gerrymandering can increase extremism or polarization by reducing competitive elections, reducing the incentives to appeal to centrists, to moderates, to independents. Is this something that you've seen? Do you feel like Republicans are more emboldened in their majority and less willing to compromise?
Georgia is a highly competitive state, right? So it runs the gamut. You do certainly see state representatives and state senators from solidly conservative areas that are changing, but their views are still very much aligned with the more conservative parts of the party. And you also see that on the Democratic side, but to a lesser extent because they're not in power. Their bills don't get hearings or votes as frequently. Where you do see a difference is in, especially those northern Atlanta suburbs where there actually is some level of competition, right? Among those state legislators, you do see some moderation, right? It's when you go into the more extremely gerrymandered areas where it is more heavily tilted toward one party or another that there's no incentive to be moderate. There's no incentive to be in the middle of the road. But if you're in a place like Johns Creek or Sandy Springs, or even places like Forsyth County and Cherokee County in the northern suburbs, which are currently Republican areas, but changing because Georgia is a growing state and becoming more, it's always 50-50 these days, right? So in those areas, you do see legislators be a little bit more careful in some cases and try to appeal across party lines to some extent. But when it comes down to it, ultimately Georgia is a still Republican controlled state at the state level. Georgia does have 3 Democrats in office at the federal level, 2 Senate seats, and have won 3 federal elections recently on a statewide basis, the 2 Senate seats and President Biden in 2020. But overall, Georgia is at the state level a Republican held state. And we do see that almost all of the majority's members step in line, right? They can vote their conscience, they can vote what they think their districts represent, but ultimately we do see the party controlling the agenda and being able to do whatever they feel is most beneficial to their viewpoints and their electoral power.
Got it. Thank you.
So it's nuanced, right? I mean, we even saw that in 2019. Like, for example, the abortion bill, right? When Georgia passed a partial ban on abortion as soon as fetal cardiac activity could be detected. You know, it passed with one vote to spare. I believe the vote was 91 in favor when they needed at least they needed more than 90 votes, half of the House of Representatives, to pass it. And the Republican Party had more seats than that, but there were several Republicans, especially in those suburban competitive areas, who weren't comfortable with voting for abortion bans. But it still passed, right? And that's generally the pattern we see. The majority party has a comfortable enough majority that they can still get through their agenda without many problems.
Got it. So let's travel south from Georgia down to Florida, my home state, and talk about the redistricting scene there, which I find very distressing. Because in 2010, when I was still a Florida voter, at the last Florida election in which I voted, in fact, there was a huge success in the fight against partisan gerrymandering. So we, the voters of Florida, amended the state constitution to ban both partisan and racial gerrymandering and vote dilution. I mean, the goal of these amendments was extremely broad, to guarantee truly fair maps that are representative of the state and are not drawn to dilute any particular community's votes. You know, at the time, I think it's fair to say this was a kind of gold standard. Like the language was very robust. And in the coming years, the Florida Supreme Court enforced that language and struck down extremely discriminatory maps and mandated much fairer maps, maybe not perfect, but much fairer. But now here we are in 2023, and the state of Florida, both the state legislature and the congressional maps, are wildly skewed. Ron DeSantis played a major role in implementing super skewed maps in the wake of the census. And, you know, so I'm going to open this up to the panelists, but I'll just say this, for me, this is kind of shifting us into, well, we know the problem. What do we do about it? And to my mind, the Florida example shows that one thing you don't do is entrust state courts, at least when they are very easily captured by partisan interests. Because what we've seen is that Ron DeSantis has taken control of the Florida judiciary, in particular the Florida Supreme Court, and stacked it with very, very conservative jurists who have shown absolutely no interest in enforcing the Fair Districts Amendment, even though they are, in theory, duty-bound to enforce it as a provision of the Florida Constitution. So, Ruth, I want to sort of open this up to you. You can correct me if any of my account was wrong, but I'm curious to hear like what you think of Florida's current maps, what you think of the Fair District Amendments, and what you think is a model or an anti-model in what Florida did to try to solve this problem.
Yeah, I'm with you. The maps are garbage. But I also agree with you, right? Back in 2010 is also when I was sort of working in redistricting, and we thought it was so fabulous, right? Good old Florida had passed this amendment and stopped intentional discrimination, as well as vote dilution. And even though I don't know that we loved the courts in the last decade, the litigators were very careful to get really, great decisions. So it is a good point that you say we can't necessarily trust state courts. It's not that all state courts are bad. Some of them do an okay, job. And there are some people who maybe, have a D or an R in their name, but they're willing to sort of look at something that comes in front of them fairly. Fortunately, that's not likely to be the case in Florida. I think that you can affect the people that draw maps, the powers that they have, and the process that they use. And so this was really great because it was affecting the powers, right? They didn't have the power to do gerrymandering. The problem, of course, was that the process was Ron DeSantis could jump in and force them to pass his own map on the congressional front. And then the people that were doing it, well, was just one governor. But then with respect to the state legislative districts, it was the people who will be elected from those districts. And I should really pass this over to Mark because, to talk about independent commissions. But one thing that you can do is have sort of independent redistricting commissions. I'll just make a plug for another thing, which I think could have some use, which is to adopt state voting rights acts. You're still going to have to rely on state court judges, but to the extent that you have a discriminatory results, or effects test, that would be more clear how a judge would have to come down when you're looking at partisan intent. I think it gives the judges room to maneuver a little and say, well, I'm not really sure, this is partisan intent or racial intent. So I think that could be one strengthening, but I think the gold standard are independent commissions.
One thing I just would add, I think that the posture of the case is that the Florida state courts applied sort of a similar Purcell rule that the U.S. Supreme Court did with respect to, or at least we think the U.S. Supreme Court did with respect to Alabama, and said it was just too close to the election to change it, even if the Florida amendments did require a change. And so I don't think we know, I think we can prognosticate what the state Supreme Court is likely to do based on its makeup. But, there's still, hope springs eternal. There's still some chance that once the trial concludes and there's, a judgment and an actual decision, that the state Supreme Court will follow its own precedent in enforcing the amendment. And I think this ties a bit into a different case that I think we're going to talk about maybe in a little bit, but the Moore v. Harper case too, about the power that a state Supreme Court has to make decisions about the lawfulness of congressional districting. And, I think that there probably was some concern that one thing this Florida state Supreme Court might do as a way to get around the fair districting amendments is to conclude that it was violative of the federal Constitution's electors clause. And so I think whether that remains a route for them out of their own state constitution, I think we'll know more about in June.
All right, you've invoked Moore v. Harper. Let's just get into it now. What is Moore v. Harper? Why is it an existential threat or not? You tell us to fair districts.
So I'm not as apoplectic about it, simply because let me back up. So Moore v. Harper is the case, or I think it was Harper v. Moore at the time, in North Carolina, where the North Carolina State Supreme Court ruled under its state constitution that the congressional districts and the state legislative districts that the legislature enacted were unlawful partisan gerrymanders, and it applied an assortment of provisions, the free and equal elections clause, First Amendment, equal protection provisions, to say that this violates the state constitution. And the legislature has appealed to the U.S. Supreme Court, which granted the case, on the argument that the U.S. Constitution places the power to do anything related to congressional districts, so the time, place, and manner of holding elections for Congress, that it exclusively places that power in the state legislatures. And so in that respect, they are acting as federal officers, if you will, and are outside the reach of the state Supreme Court to say that in doing this federal task they've been assigned, that they are violating state law. And so that's what's known as the independent state legislature doctrine. And that has been gaining steam among sort of litigants and some justices in recent years. You saw it in the 2020 elections pop up in sort of the aftermath, the litigation explosion aftermath that happened after that election, about whether or not state officials or state legislature, ironically, Republicans argued that the Pennsylvania state legislature lacked authority under its state constitution to change the mail-in balloting system there, so that irony was never addressed. But this argument has gained steam, and some justices have suggested, Justice Alito has suggested, that he thinks it's right, or some version of it is right. Now, the reason I'm not having, staying up all night about this is that the U.S. Supreme Court denied the request to stay the decision of the North Carolina Supreme Court while it considered the case. And one of the main factors that the U.S. Supreme Court considers in deciding whether to do that is the likelihood of success on the merits. And if in their judgment, the North Carolina legislature were likely to succeed, I think it's quite they would have stayed the decision below, as they did. There was a stay granted in the Alabama case, queried with Justice Kavanaugh whether that was on the merits or not. But so that's why I'm not apoplectic about it. And I think that the argument as well, if you listen to it, I don't see 5 votes for saying that the legislatures are these supreme entities that can't be constrained by their state constitutions. But that's the basic gist of the case.
Would others like to weigh in?
I mean, I'm more head in the sand. I don't know that I just, it's strange to me that in this case, I think, Roberts has written a dissent in this earlier case, Arizona Independent State Legislature, where he essentially full-throatedly adopts the independent state legislature, I would call it theory, not doctrine. And so we're sort of relying on others, probably, again, Barrett and Cav, to go on the right side here. But then there's also just the version of this where it would be insane if it wouldn't just be like state courts can't enforce their state constitutions, but also governors have no role, and like all laws related to elections are only done by the sort of state house and senate, particularly in a world where there's nothing to then govern if those legislatures are completely partisan, gerrymandered, racial gerrymandered, or otherwise. The court does insane things all the time, so maybe that's not a reason not to. But there's also a chance that it's mooted because the extremely partisan state Supreme Court in North Carolina, right? They changed the composition of the state court, and they've decided I think it was sua sponte, to just rehear the case, or maybe they were in league with the state. But it is very likely that they're going to reverse that original decision. That may not moot out all of the case, but maybe changes the sort of salience of any decision. We'll see.
Right. As an observer, it just seems so counterintuitive that this case is about whether state courts can enforce state laws, right? That seems kind of how our system is set up, and this case seems to be trying to undermine that.
And you would think the conservatives on the court would be about state courts being able to enforce state law, right? Isn't that federalism all the way down?
So we've talked about the good and bad of state courts and redistricting. Mark and Ruth both mentioned independent redistricting commissions. I would love for either or both of you to just briefly talk about independent commissions, bipartisan commissions, the difference between the two, and why you think that independent commissions are currently like the gold standard of redistricting reform. Mark, you can start.
Well, I think it's clear from our experience this cycle that an independent commission made up of actual citizens is a model that works, and a bipartisan commission made up of equal numbers of both political parties who are, usually legislators or office holders, does not work, for much the same reason that legislative redistricting is bad. And so Michigan is sort of held up as the prime example this cycle. Arizona, California, Colorado are states that have true citizen commissions as well. But in Michigan, it has sort of the most robust set of guideposts and protections and guardrails to ensure that the process actually works as it was intended. If you spend some time looking at the amount of public outreach and transparency and hearings that were conducted and comment collection, the number of people who applied to be commissioners, it really is sort of, as someone who loves democracy and loves, thinking about this, and it's sort of chilling how great of a system was put in place and how much it worked to have fair maps, but to get the public involved and invested in understanding why redistricting mattered to them and why it matters to the outcomes of decisions that are made. And so that was a real success story. Other states that had these bipartisan commissions are sort of half, I'm not going to say the word, who have worse commissions, like Ohio and frankly Washington State and Virginia, saw different levels of failure. So Ohio, the state Supreme Court, 3-4 times said that the attempts to draw maps were unconstitutional. and they just couldn't bring themselves politically to follow the Constitution. And then a federal court had an unexplainable decision putting in place one of the maps that the state court had rejected. Virginia worked out okay in the end because they had the foresight to put this sort of fail-safe that the state Supreme Court would appoint special masters if the commission failed. And that, thankfully, because of the folks who are on that state Supreme Court, that worked as intended. Washington was a disaster, and full disclosure, we're currently suing them over their state legislative maps, but they didn't even adopt a map. They sort of came to some sort of agreement about how political breakdown, and then after the deadline worked out a map. And so we've not really seen great success in the bipartisan commission world, but Michigan serves as a model for how states can fix this.
Yeah, I wanted to add to that. So I talked before about how you can change the people and the powers in the process. So on the process front, I do think when you're adopting an independent commission, you want to have a great process that's open to the public, you involve people, and you have sort of online portals where all the data is available. But that alone will not get you there. Texas actually provides all of its information online, and you can make submissions, and it's just sort of into the void. So I feel like there's that. And then on the other side, with the powers that you use, that was where we were talking about Florida, and Ohio was another example where it was look, we're not going to be able to get this independent commission, but maybe if we can make there be some sort of partisan fairness criterion, that will help us. It kind of hasn't worked. So again, I think sort of people is the really important thing that we've learned from this last decade, right? You need to get a citizen independent commission and then work out sort of appropriate rules and stuff for them.
Thank you. So one last question before we turn to the questions from the audience. Mark N., I'm curious, you've given us the sort of dark, bleak view from the voting rights wasteland of the Peach State, where Republicans get together in their dark, smoke-filled rooms and draw maps designed to drive Democrats out of power. Has there been any kind of discussion, serious discussion or otherwise, of redistricting reform in Georgia? And if that were to occur, what would it look like? Are there any mechanisms beyond amending the state constitution that could get the state there? Is this something that's feasible, or is it sort of a pipe dream that's never going to happen?
Currently, it's a pipe dream. There are bills introduced every legislative session by Democrats to create independent redistricting commissions, and every year they go nowhere. And there's no reason there are lots of reasons on principle that you can argue that these bills should advance, but politically, there's no motivation to move forward with these bills or even give them a hearing. It's not in the interest of the majority politically to want this at this time. And even let's say 2019 or so, before the 2020 elections, when Georgia was at this sort of tipping point where Democrats were making significant gains, came close in the 2018 governor's election, and as proved to be true in 2020, were on the path to make gains in the Senate and presidential election. I wondered in 2019, would the majority party think about the future? Think, well, maybe this is the time before we lose power to consider a redistricting commission and, put it in place, because if the Democrats take power at some point in the future, then the roles would be reversed. What incentive would they have politically at that point to give up some of their power? And why wouldn't they do the same things that the Republican Party does and try to safeguard their majority, which, to be fair, the Democratic Party did do when they were in control of the General Assembly in Georgia back 20 and 30 years ago. And, a lot of Republicans use that as a justification. Well, the Democrats did it to us, so why wouldn't we do it? So it's difficult to see a political will to make this change. It could happen at some point in the future, perhaps. I do believe that the golden time for it to happen is when the majority really is in fear of losing their power and wants to pass something more independent that can be in place for the long term. But really, where we are in Georgia now is the Republican Party does have a pretty solid majority, at least for the next few years. And so I wonder if perhaps the next opportunity might be at the end of this decade, right? When migration patterns change, population growth continues, and Georgia continues to be a highly competitive state.
Can I just
Very,
add,
very
I think
interesting.
that it's so true. You've got to convince legislators that they might lose power. That seems to be the only way. But legislators, I don't know, they always think they're going to have power. Like Democrats had control of Ohio in like 2002, and they were like, we're not passing an independent commission. We're going to have power forever. And then like 2010 rolls around. No, they don't. It's true that that's what you need to do. And it's so frustrating that legislators, I mean, maybe because their job is to try to win, they always think they're going to win.
Yeah, that's true. So then you wonder how else could things like this be done? And the answer to that is direct referendum or constitutional amendments. Also difficult to do, especially in a state like Georgia, which makes it very difficult for questions to get on the ballot for voters to decide. It almost always requires a approval of the General Assembly first. But that is another path. You know, other states have done that where as part of a method to have more direct democracy.
One, I think, salient example of the convincing them that they might lose power. I believe this is the case that in North Carolina, when the Democrats were in charge of the legislature, got the Constitution changed so that the governor would no longer be able to veto or had no role whatsoever in redistricting because they thought there was a risk of there being Republican governors, which had happened, but that the legislature would always be Democratic. And so now here we see ourselves with a large Republican majority in the legislature and a Democratic governor, and he has no power to veto the maps. And that's why we're even here talking about Moore v. Harper, which we wouldn't be if he had been able to veto those maps. So
really interesting. Thank you all. We're going to turn to some questions that folks have submitted. There's still time to submit more questions if you're curious. And I'll once again tell you at the end the email address you can reach out to if you want to hear even more from our experts. But we're going to start with Sue's question. Sue asks, aren't we still feeling the effects of concerted efforts in the 2010 redistricting cycle of one party to gain control of state legislatures, and how can this legacy be undone? Ruth, do you want to start?
Yes, I have seen this in some of the cases I'm litigating this cycle. This is sort of an unfortunate blurry area in the law at the moment where respecting existing political communities is considered a legitimate criterion. And so if you have drawn a gerrymander back in 2010, you could say, well, that district is a legitimate political community, and we need to keep that group together. And so, yes, you are absolutely right. I think that those legacies do live on, and they become hard to get rid of. It is something that is sort of trying to be attempted in various places, but I think basically tying together the fact of like it was bad then and it's still bad now, and trying to get rid of it for that reason, and sort of being realistic and honest about the fact that the problem has carried through. This sort of transferred intent thing is a problem in many areas of the law. So yeah, it's a huge problem. And that's also a reason why it's worth fighting really hard now to try to make changes in this decade, because then there's another decade and another decade, and it shouldn't be the case that just because we did something bad in 2010 and didn't get to sue over it, then for the next 50 years, no one can ever sue. So yeah, I think it's a real problem.
The word that's developed for that is gerrymandering, which I think is kind of a fun one.
Thank you. Okay, I'm going to turn next to the question just above Sue's from Mike, which I'm going to interpret as, I think, asking about alternate ways of electing representatives. And Mike asked about a kind of top 2, top 3, top 4 system, perhaps an at-large system where the 4, highest vote getters each get a seat in the House. Another way to do this, it's very similar, is proportional representation, which is done in Europe. Can you guys talk a little bit about like some of these alternatives and why we don't use them in elections, at least at the state level today, to elect members of the House of Representatives?
I think the first answer, so some states are doing some versions of these reforms, at least with respect to, I think what Mike's question was about there is a federal law that requires that elections happen from single member districts, and so it's statute, it's not in the Constitution, but that statute would preclude having sort of a statewide proportional representation type of election. But that doesn't stop states from having reforms within the construct of single member districts. And Maine is an example that has ranked choice voting for its election for members of Congress. That's how Representative Golden was elected in 2018, and I think in 2020 he would have won the plurality too. But other states have adopted nonpartisan primaries. The top 5 method that Alaska's adopted, combined with ranked choice voting, has got Mary Peltola elected. And so there certainly are a number of potential reforms that they don't totally get around. Unless your state only has one district like Alaska, they don't really get around the redistricting part of it. But they certainly do get to that sort of effective or possible effective redistricting, which is to have the extreme, version of whatever candidate might win from that district in the primary be the only choice in the general.
I wanted to add on the N matters, right? So the California top 2 system, I think, was well conceived of, except I think in reality, it's ended up that you can get some skewed results. So Alaska having the top 4 system, I think you want to have more than just 2 going through if you're going to have a completely open primary, or you have ranked choice voting or instant runoff, as Mike has mentioned, for the whole group to go through. And as Mark mentioned, it is a law that stops you from having, that requires you to have single member districts. So there are bills in Congress about having, for example, 5-member districts with ranked choice voting to elect. So that's sort of semi-proportional system.
Got it. And just one question for Mark N, inspired by Mike's question. Why the hell does Georgia still have a full-on runoff? Why hasn't Georgia adopted some kind of system that would allow for an instant runoff or something more efficient than what we are all dragged through each cycle? What's going on there?
Well, a lot of reasons. One, and what we're learning this legislative session, is that there's very little will to change Georgia's runoff system. AJC, we did some polling in January. 58% of Georgia voters wanted to get rid of runoffs after general elections, but it doesn't look likely that there's going to be much movement on that. Although a bill has been introduced to do so, it hasn't really moved forward. What I hear over and over from legislative leaders in Georgia is they feel like getting 50% of the vote gives candidates a mandate, that if you win an outright majority, then that's a mandate. If you reduce it to a plurality, then they don't feel that's a real show of confidence in a candidate. So through a runoff, you do end up with one candidate that does have more than 50% of voters who chose to turn out in runoffs, which almost always encompass less than half of Georgia's registered voters. But among voters who come out, you do end up with a mandate of 50 plus 1%. As for instant runoffs, there is some bipartisan support for that, but not enough for it to move much further. There is a Republican-sponsored bill that would extend instant runoffs to city elections, not on a statewide level, but started a little bit. And Georgia's voting law passed 2 years ago. It did institute instant runoff elections for overseas and military members. That was done as a way to shorten Georgia's runoff period to comply with federal laws to ensure that military voters have time to return absentee ballots. But ultimately, the main reason why instant runoffs won't move forward in Georgia is because it's a national priority of the Republican Party to oppose instant runoff or ranked choice voting. That's part of the platform. And also a lot of Republicans saw what happened in Alaska, and where Sarah Palin lost in a House race that did have ranked choice voting, and they don't want that to happen here.
But do you think the Georgia system actually favors Republicans?
Does it favor? I don't think it really favors anyone. In runoffs, most of the time, the candidate that won, that was leading in the general election, ends up winning the runoff as well. The recent examples in 2022, Raphael Warnock was ahead of Herschel Walker in the general. He won the runoff. In 2020, we saw that David Perdue was ahead of John Ossoff in the general, but Ossoff won the runoff. So that was a difference. But Warnock was ahead in the special election in the general and went on to win the runoff. I saw a message from a state legislator who sponsored Georgia's bill to go to plurality vote this morning. And she, according to her tally of 8 runoffs in like the last 15 or 20 years or so, 5 of them have been won by the winner of the original election. The 3 exceptions were that Perdue versus Ossoff race in 2020 and 2 races for the Public Service Commission in 2006 and 2008, I believe. Most of the time, and there were split results in those PSC races. One favored the Democrat, the other favored the Republican. So most of the time, the winner of the initial election does come out on top. So I don't think there's really a favoritism. I mean, one argument that could be persuasive to Republicans is, look, Democrats are winning runoffs in Georgia. You thought historically that runoffs favored Republicans based on the belief that Republicans were more consistent voters, but now Democrats have shown an ability to mobilize again after a general election and outnumber Republicans, especially as we saw in the late 2020, early 2021 U.S. Senate runoffs. However, from what I've seen, that isn't a persuasive enough argument to try to change the system.
Fascinating. Thank you. I so appreciate this rare insight into Georgia politics. So we only have like a few minutes left, and I just want to turn to Mark G. and Ruth briefly so we can wrap this up. If you can give me like a closing thought, what can be done in the next few years to make redistricting fairer in the future? What is at the top of your wish list?
Well, I think at the top of mine is for folks, I think there needs to be sort of a groundswell whenever possible for folks to encourage and where they have the power to actually just do, to get ballot initiatives, start circulating and get them on the ballot to adopt independent redistricting commissions. I have a small amount of hope that maybe Congress could do something. Even if it's not as visionary as the For the People Act or whatever it ended up being called by the end of the day, even some small incremental change to reset the federal floor for how this happens in the states, I think would be a useful thing to change the way that this occurs. And as Ruth mentioned, I think any state where it's possible to pass a state voting rights act, I think ought to, and folks ought to encourage that because those can add additional strong protections. And we've seen some of that in states where that's succeeded.
I completely agree with all of that. I guess I'll just add, I think it's important that we keep fighting against the sort of problems and set the sort of legal record this decade for next decade, vis-a-vis Sue's question. And then the other side is just not to forget that redistricting happens all of the way down. And there are many places where local redistricting, school board redistricting, and all these ththings are still going on. There are places that want to get independent commissions at the local level, and there are ways you can be involved to do that. And so it doesn't have to be like, oh, well, we missed this decade, we're done. I think you can still keep going. Groups like the NAACP and the League of Women Voters are sort of consistently out there on this. You can join those groups and sort of hold local leaders accountable. So stay in the fight, I guess.
Wonderful. All right. Well, with that, a really optimistic close. I would like to thank all of our speakers. And of course, I would like to thank the viewers and commenters for joining us today. If you have any additional questions or would like more information, just email CLC at info@campaignlegalcenter.org. That's info@campaignlegalcenter.org. Thank you again to everyone and have a great weekend.